Mesanso Eddie Aquabacasi Emma Aya for Nebusia and Sambi Kosu Micro Ghana Natchez Mesro or subscribe like share video no at the Amauni and Ianco and Koti Assembly in Chill Nebusia Aya Honorable Afenyo Markins Eddie Summer Horna Eddie Ababa 2 and Mountain Suna Efa NDC Amanyukunu Esika Samu and you may be our known to say NDC Amanyukunu Ayen no no the Ababa 2 Mountain Suna or the Bell 2 and now almost aso asem no emu osoro na tese omo chen sen sema oka ni na nimrem so wo hwe Ghana constitution ni emu a na tese o kire sentinu president na adekodi amahama epese oye na ono so esa betwa another term na tese Ghana for engine tum no eno o kire sentinu ade a e wo se e ba so pan yi pa na tese nya asem kitwa kra epese his excellency John Dramani Mahama esa ba e betwa another term edeka esa ne term we a utwa no ho na no na omo kire sentinu sansam we ento asum so wo de constitution ma enya de eto asum na be ye tempo se obeye sa de no busua nsem bebre na lawyer bi e de ababeto monte so na tese me se o mere misaka audio sa ho na e wa se enkoji enchire mumbra
but in Tamale when he filed the petition lawyers for Mr. Or Honorable Matthew Yindam actually applied to the court to have it struck out had been premature. And their contention was that at that time, our candidates should have waited for the gazetting of the result before mounting the petition action. So quickly, the lawyers withdrew the petition so filed and waited until the Electoral Commission itself now gave an indication that on the 6th of January, this is the Gazette notification. So, in an affidavit deposed to by Matthew Yindam himself, he attached what he claimed to be the Gazette by the Electoral Commission. He attached it to his application. Now, this application that Matthew Yindam actually put before the court, subsequent to that, the MP, that's the NDC parliamentary candidate, now issued a fresh, now issued a fresh petition after this gazette. And if you look at the deposition by Matthew Yindam, one of the things that he said in his affidavit in support, which is sworn to, and you see, when we say deposition, you swear to. What it means is that if you lie, you risk perjury. Now, in the deposition that he put before the High Court, one of the things that he said is that I just want to read, that available records show that the parliamentary election results of 7 December 2024 nationwide, including that of Pandai constituency, were published in the Gazette or gazetted by the Electoral Commission on 6 January 2025. Attached hereto and marked as Exhibit this is the page of the Gazette relative to Pandai constituency, a soft copy attached hereto. So pursuant to this, the NDC candidate then withdrew the application, the petition, and refiled it based on the 6th of January Gazette notification. Now, after the High Court in Tamale had delivered its judgment, after calling witnesses, both the Electoral Commission came to testify, he himself testified, through his witnesses, and our candidate equally testified. The High Court judge in Tamale delivered the judgment. Now you are the Supreme Court saying that at the time the NDC candidate filed the petition, the 21 days gestation, the 21-day period had elapsed. And for that matter, the High Court was bereft of jurisdiction.
What's your opinion? That there's no merit in this?
Completely without merit. Because, hold on, I've just read the affidavit deposed to by Yindam, where he himself swore to the court that on my honor, the Pandai Gazette relative to Pandai constituency declaration is 6th of January. Now you are before the Supreme Court. Now telling the Supreme Court that no. It is not on the 6th. I lied.
NDC, I'm surprised at your
perjured,
position because
and that I have engaged. Hold on, I have engaged in perjury. And so look, the deposition is before a superior court, the High Court. Always remember that an application for certiorari is a discretionary remedy. So even when you have satisfied all, the court can still deny you based on your conduct. And when you have deposed to an affidavit telling the High Court subsequently that I lied, that when I told the High Court in my affidavit that the declaration and the gazetting was on the 6th of January 2024, I peddled on truth before the High Court. I mean, how can you do this? And I'm surprised.
Because, the reason I was questioning was that this follows greatly what the minority leader had also espoused in his press conference and thought that the judiciary, based on his position and his assessment, was becoming almost like one that was being controlled or manipulated.
You see, when I heard my learned senior, Afenyo Markin, make that statement and described the whole thing as kangaroo, I felt pain within me. Look, I am not speaking about somebody's lived experience. My own experience. Look, I recall vividly our MP for Afenyo, Jachi Kwesi.
The Deputy Foreign Affairs Minister. Okay.
At the time Jachi Kwesi, this thing came. Remember that we're going to have the Speaker's election on the 6th of January, the 9th. So,
of 2021.
Yes. The High Court judge
2024
in Cape Coast, there was supposed to be a demonstration in Winneba. So the High Court judge in Cape Coast was given a special warrant, listen carefully, was given a special warrant to go and hear an injunction application to restrain the NDC supporters. Then they brought an ex parte application for injunction to restrain Jachi Kwesi. When the judge saw it, he said, oh, this one they should come on notice because you are seeking to restrain a member of parliament duly elected. Guess what happened? Our law firm represented Mr. Jachi Kwesi. Myself and my senior Amaliba worked on that thing.
The case?
The case. So we quickly filed affidavit in opposition to the injunction application before the High Court judge in Cape Coast. Guess what happened? We were clear because we had raised certain critical constitutional issues. That one, Article 94, which has to do, he owes allegiance to no other country but Ghana, requires constitutional interpretation. But because the last time it came up was Bilson and Rawlings, where the High Court judge took the view that the question as to whether a person owes allegiance to a country other than Ghana simply means that you cannot stop Jerry Rawlings from contesting the 1992 election because, in your view, Bilson's claim was that Rawlings' father was a Scottish, and therefore he was a dual national. The High Court judge, Bonzi, took the view that having served in the Ghana army and having become head of state for almost 11 years, it was ridiculous for anybody to now come and say that Jerry Rawlings was a dual national and for that matter. So we felt that this was an opportunity for the Supreme Court to construe what it means when you say a person owes allegiance to a country other than Ghana. So in our affidavit in opposition, we raised those constitutional matters. Guess what? The day we went to the High Court on the 6th of January in the morning for the ruling on the injunction, we got to court only for the judge to say that he's granted the injunction. Listen, no, he's granted the injunction to restrain Jachi Kwesi.
Was he untoward?
From 1972, even Moro, Igala, and the rest, there had never been any instance where Proud to the hearing of an election petition and concluding the MP-elect had been restrained. Because we did the legal research. There was no search. Guess what? The judge restrained us. And this is where it gets interesting. But the day before, I had a senior party officer